Joydev, that you are a PhD scholar from Utkal University. You are pursuing your PhD in law. So not taking much time. So let's listen to you and welcome Ankit. So the stage is all yours. So please go ahead.
First of all, thank you for this splendid introduction, and I'm thankful for the organizers. I'm thankful for the organizers who have created such a platform so that people like me who can share their knowledge with the people who are eager to listen, eager to learn. So very much thank you to all of you. So fundamental rights. I would like to start with a note that fundamental rights is not a new topic for us. All of us who have completed our higher education from some universities or other, especially those from the backgrounds of political science, public administration and law, or sociology even, they are very much well acquainted with this concept of fundamental rights, because it is a very burning topic, and we as fundamentally as Indian people, we are very much conscious about our rights always, that this we can do, that we can do, this we should be treated like this by the state, and all this. So first of all, I like to for those who are just in your introduction, you have mentioned various kinds of fundamental rights. For those who are not that much acquainted with these fundamental rights, I would like to have a brief introduction for them. But what is fundamental rights? So fundamental rights, it is in the part 3 of our Indian Constitution, the Constitution of India being the supreme document of our country, it is regarded as the supreme document of our country. And from this document, all other legal documents or statutory documents of the country and the state, they gather their authority. So it is kind of a supreme document, and ultimately the Constitution of India gathers its authority from the people of India. So Constitution of India, it is constituted by the group of people, and they are called that Constitutional Assembly debates, and all they have discussions among themselves. They referred or they got inspired by many other foreign constitutions and created this, and it is adopted and enacted by the people of India in 1950. As you all know, we celebrate this as Republic Day in January 26. So Constitution of India, it has many parts, and its part 3 consists of certain amount of varieties of rights which it provides to the people of India in general. People of India means any person in India who is an Indian by birth or who is residing within the territory of India, and it is vast in nature. And as the organizers have already said during the introduction, there are some rights also available for the aliens also, enemy aliens. Enemy aliens means those people who are not from India or not the citizens of India, but from outside countries or abroad. And also, enemy means in case where our country is in position of war with some country, it is called an enemy alien. So the inhabitants or the citizens of a country with which India is at war, we would call them enemy aliens. So even those who are enemy aliens, they are provided with certain kinds of rights. So Indian Constitution is means a document. It entails liberal concepts. It is not strict. It is not based on vengeance. It is not based on harm. It is a positive document. So part 3 of the Constitution, it starts from Article 12 to Article 35, I think, of Constitution of India. It has many kinds of rights. Like initially, it declares that which is state Article 12 declares about what is a state, and with the central governments are the state, individual state governments, and all the authorities established under those central or state governments, they are regarded as state or parts of the state. Then there is Article 13, which says, it is a very important Article 13 because it declares, Article 13, that all the laws which are prevalent before the adoption of the Constitution, before 1950s, or the laws of the British era, or the laws before that, all the laws which are prevalent and which are not consistent with the fundamental rights as provided by the new Constitution of India. Constitution of India, as we know it, shall be void. So, in Article 13, it says, first of all, it nullifies, it stops the application of all laws which prohibits the fundamental rights provided by the Constitution of India. And then it starts with creation of fundamental rights in our modern independent India. It starts with Article 14, which is commonly known as right to equality. It is a very important fundamental right. There it says that no person shall be, the state shall not deny any person's right to equality, equality before law or equal protection of law within the territory of India. So it is, in short, it is called right to equality. Then there is articles like 15 and 16, which removes discrimination by the state, discrimination in any form, and discrimination in cases of public employment. Of course, there are much debated topics like special provisions for special classes of people and various policies, difference, reasonable classification, reasonable and discrimination on the basis of backwardness or the, you can say, weakness of certain sects of the societies. But basically, the Article 15 and 16 of the Constitution, it entails that the state or any part of the state here means in political science or tend to law, we state means we consider the nation itself. So the nation shall not discriminate anything on ground of age or gender or race or religion or anything. But it is empowered by the Constitution to make special provisions, of course, so that the object of that employment or object of something which is policy, any government policy, need not be violated. And after that, there is Article 17, which is very much means it is very popular, because popular in the sense it has prohibits any kinds of any practice of untouchability. Untouchability was a drastic characteristic of our older society, where it was very, it had much deep ripples, negative ripples in our social fabric, and for it was only many personalities were shaped in such a way which is derogatory to the unity and the integrity of India and all that. So it prohibited untouchability and abolished untouchability. And later, basing on this article, in 1955, an act of the Parliament or a law came which says Abolition of Untouchability Act, and later its name is modified in 1976. That Civil Rights Protection Act. Today we know it as Civil Rights Protection Act. And earlier the act itself had the word untouchability. So people objected to it that how can we remove untouchability if the act itself says it is untouchability. So this is a trivia. And another thing is there is Article 18, which prohibits people from taking titles from foreign authorities. It's not that much important. And then comes the one of the most debated right, that right to freedom of various sorts, like freedom of speech and expression, and there is a freedom to move anywhere within the territory of India, and there is a right to carry out any profession, and there is a right to assemblies and forming right to trade unions and all this. So here, as it is specifically mentioned that the freedoms provided in Article 19 is available to all of the citizens of India. They are allowed to express their freedom of speech and expression. They have right to assemble. They have right to carry out any profession trade. However, it also restricts those persons on the grounds of public order and unity and the integrity of the nations and bilateral relationship between the states, and all these grounds. There are some reasonable restrictions are there, which is later discussed in that year. So basically, the concept of fundamental rights here it covered the various kind of freedoms. A human being needs freedoms to express himself, to be the best person himself, to be at the disposal of the state or the society in his best possible manner, so that he can contribute to the growth of the nation as a whole. So here the Constitution of India provides various freedoms so that person can be improve himself and the society as a whole. He can be speak whatever he feels. He can empower other people also through his knowledge, and he can carry out any profession, trade. He should not be restricted by virtue of any discrimination, not to do some trade or business. Of course, there are reasonable restrictions in interest of states, but the general rule will be the freedom, of course. And there is there is Article 20. Article 20 says. Article 20 basically is divided into three parts. The first part says it says about ex post facto law. Ex post facto law, it is a Latin term, which usually law is accused or criticized as a very voluminous topic and hard to understand topic, because all these numerous provisions are there, numerous contradictory rules and regulations are there, and there are use of Latins and Greek quotations and all that. So it is not completely true, because as far as I have traveled through my journey as a law student, and now I am serving as a teaching personnel in a certain university. So I have felt that law is law. No doubt, it is voluminous, big in size, but it is not that much complicated. If you want to understand it, you need not know what all the laws are. Simple. It's as simple as that. You need not know what all the laws are. You just know how the law works and where the law is. That's it. And when you want to understand that law, you can easily peruse that particular piece of provisions, the precursors of that provisions, the effect of that provisions on the state, and you can understand that. So here in Article 20, it's the first portion of the Article 20 says ex post facto law. Ex post facto law means a law having applicability before its time. So let me explain to you what does it mean. So Article 20 ex post facto part 1 says, the clause 1 says, if a person commits any crime or any wrong as per the laws prevalent in our constitution and in our country, any law, not just only constitution and everything, any law in our country, he shall be punished as per that law, which during the commission of that crime is prevalent in the law of the land. More practical example would be if a person commits a crime in 2015 January, then he shall be liable for the laws which are prevalent in India for in 2015 January. He cannot be made liable for a law which is made applicable after January 2015. How it practically affects the society? You might have remember in the cases of in the famous case that Delhi gang rape case of Nirbhaya. There at that time the commission of that offense of rape, there is no penalty of death in the rape laws in India. Then the people needed that most stringent punishment, and the government and the parliament came with the harsher punishment for rape and sexual assaults, and it had got they have created this stringent rape laws with death punishment. But however, the people who are found guilty and executed in that case are executed for the death of the victim, not for the rape of the victim, because at that time, when the crime was committed, the law was not to punish rapists or sexual assault people for capital punishment or death punishment at that time. So it cannot be applicable. This is the simple concept of that. When the crime is committed, at that time, whatever the law was, it will be applicable to that criminal. Later, whatever law becomes, it is not important. So it is called ex post facto law, and the constitution protects every individual of the state or the country of India from this latter application of the law. It protects everyone that any future law cannot make liable a person for his past offences. This is simple. There are exceptions that apart from criminal cases, in certain cases relating to financial matters like taxation and all, some laws can be made applicable from the past also, but not in the cases of crimes. So this is first. Second part of the Article 20, it says, no person shall be prosecuted for the same offence twice. It is in legal language, it is called double jeopardy. That means if a person is already punished by first commission of certain offence, he has committed some wrong and he has been punished, he cannot be punished again for that same offence. And last part of the Article 20, it says that no person shall be compelled to give evidence against himself. It is a very importantly, our topic of the today is fundamental rights and the common man. So in Article 20 and this last part of the Article 20, the third clause, this is very applicable to a common man. The common man should know that he can never be compelled by the law of the country to give evidence against himself. If he voluntarily gives evidence against himself, which is known as confession, we know it is confession. If a person is confessing and is admitting his guilt, then it must be voluntary in nature. It must be before an impartial authority, such as a judicial magistrate or any rank above that judicial magistrate. But a person cannot be compelled simply to give evidence against his sin. It is accepted rule, and there are no exceptions. Not even exceptions in cases of national security and everything. Not in case of terrorist, not even anyone. Simple, because it is accepted in all around the country, all civilized countries in the world, that a person shall not be compelled to give evidence against himself. He cannot be the reason of his own conviction solely. His words might help, of course, but solely it should not be the reason of his own conviction. Then the most important article of the fundamental rights comes, which is the most vast. And if you purchase any book regarding to the Constitution of India. It would cover more than 40% of that book, 30 to 40% of the book. That is called Article 21, the right to life and personal liberty. Right to life and personal liberty, I will not delve into in detail because it will not end. What it says, Article 21, basically, simply, it reads as no person shall be deprived of his right to life and personal liberty except the procedure established by law. So, it is a very simple sentence. Let us revisit it. No person shall be deprived of his right to life and personal liberty. That means the Constitution of India ensures that a person has a right to live as per his needs and personal liberty. He is entitled to his own freedom. His freedom means his freedom can be, personal liberty can be of anything. Personal liberty means liberty to exercise rights under Article 19, which I have already covered, that freedom of speech and expression, freedom of trade, etc., etc. So all these things, a person has a right to profess, to continue, and except the procedure established by law. Except the procedure established law means the legal provisions of that country. It cannot be taken away. The life of a person or the personal liberty of a person. Numerous times and again, the Supreme Court of India, who is the guardian of the, regarded as the guardian of the Constitution, it upheld the rights of the individual over the whims and fancies of the states. Many times by many political authorities. I'm not speaking about any party or any leader. Many times by various parties, various people in power, they have used their legislative powers or bureaucratic powers to take away certain fundamental rights. And in any book, you will find various number of cases in these regards, and where a person has sought the help of the courts, the Supreme Courts and High Courts. They have always, most of the times, upheld their rights, and hence, somehow, in a way, they justify the word fundamental rights. Because fundamental rights, we all know, we call many kinds of rights, that there are like legal rights, statutory rights, fundamental rights, natural rights, human rights, many kinds of rights we come across every day. So, this fundamental rights in Article 21 is protected by the organ of the state, judicial organ of the state, and it is so vast in nature. It entails many things like right to livelihood. Or common man has a right to livelihood, right to earn money, right to sustain himself. A common man has to his right to entertainment. He has a right to free healthcare, or the state indirectly has a duty to protect, provide enough health and educational opportunities, and a person has a right to, you can say, a person has a right to even free legal aid. It is a new addition to right to life, and earlier it was not there, but right to education is also inserted in Article 21. Now it is called Article 21A, which is also a fundamental right of a person. Then, Article 21, I think it is most very much discussed topic, so it is nothing. It is more of a social concept in nature rather than legal concept now. But there have been, when I go to the Article 22, you'll find it new, and it is a little bit legal in nature. Article 22, it provides for protection against arrests and detention. Protection against arrests and detention. Protection against arrest and detention. Arrest and detention are strictly legal words. It is you must have in society every day see people get arrested, people get detained by police, people get questioned by police, and in certain cases recently you must have seen in our society, they have seen people got house arrested or detained inside a certain residential premises for 1 year, more than 1 year, or long terms of period. So all this, the Constitution provides protections against this some kinds, not all kinds of arrest and detention, but some kinds of detention. But there are some exceptions also, which we got to see or get to see in our day-to-day life. So basically, it provides two kinds of arrest and detentions. One is called arrest and detention as well, which are ordinary in nature and which are in pursuance of legal modalities of our legal law enforcement agencies like police and other armed forces of the state. And there is another thing called preventive detention. Preventive detention, the term comes, the word preventive is used because that kind of detention or that kind of arrest, it is done to prevent an offense from happening. It prevents an offense from happening before the offense is happening. So sometimes it's said that when even there is no offense, so why do you have or the state have imprisoned or detained someone, taken away his rights? So it is sometimes in certain cases, as per law of the India, the state is bound to protect the peace of the land and for in national interest or the social interest. Some people get arrested or get detached or detained, and they are for protection of them. There are certain in this Constitution 22, Article 22 of the Constitution of India, there are some provisions like no person shall be detained or arrested without the official, without the application of law. Only by application of law, or in certain cases, the armed forces of the state or legal law enforcement machinery of the state, they are entitled to arrest a person. And when a person gets arrested, his first right is to know on what grounds he is arrested. Secondly, he has a right to his legal aid or right to get a lawyer in simple language. And if he cannot afford a lawyer or does not want a lawyer, the state will give him a lawyer for free. It is the duty of the state. It is called right to free legal aid. And lastly, he need to be produced in front of a judicial authority. Usually, the arrest is made in India. Arrest is made by the armed forces like police and other forces of the state. In any cases, but a police or any armed forces is usually not allowed to keep a person detained or arrest a person and detain that person more than 24 hours without the authority of a judicial member of the state or the judicial magistrate or judge or anyone of the state. So a person who is arrested has a right to get produced in front of a judicial magistrate within 24 hours of the arrest. So this is only I am saying in case of ordinary arrest and detention. These are the rights, and there are many other rights also, basic rights like right to communication, right to get a family informed, right to get a lawyer of his own choice, etc., etc. And then there is preventive detention. Preventive detention is very important because in preventive detention, the state can use its power to arrest or detain a person without getting him to produce within 24 hours to a judicial magistrate. It can himself, the state can itself keep him for a long period of time, up to sometimes 90 days or 3 months, and then he has to take permission of a duly appointed body by the government, and sometimes also even 90 days there is no limit. In these cases, we have seen many cases where people are detained in particular places for longer period of time. So those are exceptional cases. Those are not ordinary detentions, and those laws are created by the parliament itself to protect the public order or the national security of the state. And there are ordinarily there have been no protections against them. However, later will soon when we go further, will know that certain rights of the fundamental rights provided can never be taken away from a person. It can only be suspended. So, when we say that a state can detain a person for long period of time, suppose 1 year, that doesn't mean that state will not face any consequences. It does not mean like that. It means that state will face the consequences later, and immediately there cannot be any action, especially judicial action for the release of that person. So if I am arrested under preventive detention, that does not mean that I don't have a voice to speak, or I cannot proceed legally against the authority which arrested me. It does not mean like that. It only means that at that particular time, as the need of the hour suggests, as per the authorities, my rights are only suspended. Will be applicable very soon. So it is not. We should not think that Constitution of India is not protecting the rights of the people or freedom of the people. It is just. It has just in some cases kept the need of the many above the need of the few. We might have known it as that Jeremy Bentham's utilitarianism, if anyone into jurists and legal background. So it is a very common concept that the need of the many outweighs the need of the few. In certain cases, not always. So, this is Article 22 regarding the protection from arbitrary arrests and detentions. Arbitrary being which is unlawful or based on whims and fancies, nothing well disciplined. So, in Article 23 and 24, it says that there should Constitution protects its people from forced labor, or there is human trafficking and employment of underage people under the age of 14 in hazardous workplaces. It prohibits that Constitution. And after 23, there is starts socio-cultural rights, which is very well known to us. The socio-cultural rights says that any person in India has a right to protest and right to, in the sense, right to propagate, right to believe in a particular kind of religious beliefs and uphold his religious identity, his communal identity, his linguistic identities, his cultural identities, everything. And also there are it is the right it's provided to the state also to protect in the interest of indigenous tribals of the country also, to make special provisions regarding this. And if the state thinks that those tribals are not able to protect their culture and language and religion, the state can make provisions to enforce that protection of those rights, which we might have known about the protection of that indigenous tribes of Andaman and Nicobar, and how the ordinary people are not allowed to meet with them. So these are the special provisions where the state has protected the nature of their indigenousness, and it is not against the fundamental freedom of movement and freedom of speech and expression and all that. So there are reasonable exceptions to everything. And finally, there are the most one of the most important fundamental rights in our constitution, which is to protect the other fundamental rights of the constitution. When we are taught fundamental rights in our formative legal years, we are asked that if you have lots of rights, thousands of rights, but you are not allowed a chance to protect those thousands of rights, then what are the meaning of those thousand rights? This is a fundamental question. So not only we need to have rights, but we also have to protect those rights. Then only it has some meaning. So Article 32, along with Article 26 of the Indian Constitution, are the, one can say, the protective legislations or protective provisions in the Constitution of India, which allows the courts in the country, especially the higher judiciary, Supreme Court and High Court, but not limited to that, because it also says that other courts can also be empowered to protect the fundamental rights of a citizen. There are many kinds of writs. Writs for common man, writ is a kind of legal proceeding or a kind of particular kind of case, and through which a person who's aggrieved, his fundamental rights is aggrieved, can go to the court of law and seek remedies, seek justice for his protection of his fundamental rights as per Article 32 and 226. And these are the basic fundamental rights. Fundamental rights and common man, this is not a new topic. In 1971, an eminent lawyer, you might have heard his name, Nani Falkirala, who is an eminent lawyer of Supreme Court. In one of his famous deliberations in a public meeting, a speech, he had propagated this concept that Indian constitution is not an elite constitution, but it is a constitution of a common man, because it has endeavored its level best to protect the rights of a common man, and it has all the ingredients which is needed for the extraction of excellence from the life of a common man. So this topic is not unheard for. It has been already been envisioned by some luminaries earlier, and there are numerous cases where I have came across in my legal studies, because I don't think I have still completed the study of law. I am still a student of law, and in studies I have many questions that the law and the common man is far, and the common man does not understand the nature of laws and how it is applicable to the society, how to get his rights enforced and all that. So first of all, as a student of law, I'll recommend them, so don't get intimidated by its voluminous nature and its complex, grammatical sentences, long sentences. Don't, you just keep patience and read, and it is very simple. You can know everything, and it's and now people are getting conscious, and there is our also, whether I don't know our discussion today is present or not, but our discussion here is a practicing advocate, and we can also give away pointers about the practical aspects of how to enforce the laws in the courts of law. Courts of law in India are there, and there are numerous litigation already, and there to enforce our rights. So a common man need not be afraid to enforce his rights, fundamental rights, legal rights, statutory rights. He should be conscious about his rights always. And also another thing, even if it is not in our topic, I must say, as long as we should or we are conscious and empathetic about our fundamental duties. I don't think fundamental rights would be a much complex topic or much complex in our society. And as long as we'll be perfect in disposing our fundamental duties, soon all the all the fights, all the adversities regarding our fundamental rights will come to an end. And with that note, I think I should conclude, and I think I should transfer the center stage to the organizer. Okay.
Okay, thank you, Ankit. It's a really pleasure to listen to you. I think today we have another discussant, Professor Jairam Samal. So, Professor Jairam Samal, if you could listen to me and if you are there, so please have your discussion. What Ankit have discussed about fundamental rights. He has also cited, many practical things and practical examples. After your discussion, I think all are welcome to ask their questions. To Ankit also, you can ask your questions to our discussant, Professor Jairam Singh Samal, who is well versed with the Constitution of India. Jairam, stage is yours, please.
Right, by 1 second, because of this, Subrat is also there. You can also add. If Subrat is there also, you can also add. Subrat Kumar Behra.
Okay. Subrat also, after Jairam, Subrat also welcome to have his point of discussion. So past Jairam, our dear Jairam, if you can also switch on your video, we could also see you, and I think yes. So please have your point of view.
First of all, thank you, Vikas, and thank you, Ankit, for that nice presentation. Actually, I'm adjusting in place of our practitioner who is supposed to be discussed today. So, as you have very nicely presented, there is hardly anything I have to say. But still, as you all know, in case of India, we equate fundamental rights with Magna Carta. Magna Carta, if we see world history, Magna Carta, from Magna Carta, foundation of British democracy laid through Magna Carta. So that might be the reason why fundamental right is equated with Magna Carta in case of India. As our speaker has already explained, there are 6 fundamental rights, starting from Article 14 to Article 32, from right to equality to right to constitutional remedies. And he rightly pointed out in his presentation how right to constitutional remedies under Article 32, which is the most important article among all these fundamental rights. And even Ambedkar equated Article 32 with heart and soul of Indian Constitution. Without Article 32, the meaning of other fundamental there is no way to implement, execute other fundamental rights. So as our topic is, fundamental right and common man. So what we need actually in case of India, that there is a lack of constitutional awareness. In case of India, we don't know our fundamental rights, starting from school to college debut. We have very abstract idea. We don't have much idea. But one thing we have to keep in mind, in addition to our cultural and civilization unity, it is Indian Constitution, which binds this country, starting from Kashmir to Kanyakumari or Gujarat to Arunachal Pradesh, with so much of diversity and difference. It is Indian Constitution which binds us, which makes us Indians. In addition to our civilization values, that we have tolerance, cultural diversity, all other things. So basically, in case of India, the fundamental rights are negative in injection. They prohibit state. If we look into fundamental rights, they prohibit state from discriminating among its citizens. And these are, as we all know, as per Article 32, these are justiciable. In case our fundamental right is violated, we can approach in Supreme Court under Article 32 directly, Article 226 in High Court directly. If we see in case of India, fundamental rights are, if we take our constitution as a living document, fundamental right is more vibrant. If we see the fundamental right, it is growing. Like it said, Article 21A, which is added in 86th Amendment. Right to education is a fundamental right now. It's no more a fundamental duty. Similarly, if we see Supreme Court interpretation or Parliament interpretation, right to information, it is now regarded as part of Article 19(1). If I have to right to freedom of expression, I have right to know first. So right to information is now regarded, it is come under Article 19(1). Similarly, when during voting or election, we have every right to know about the property statement, criminal record of our representative, those who intend to participate or contest election. So our fundamental right or constitution is growing and adjusting with changing need or requirements. So it is a living document, and Supreme Court has already explained in its verdict that fundamental right has to need to study along with DPSP, Directive Principle of State Policy. If fundamental rights are given political democracy, then socio-economic democracy, Directive Principle of State Policies are also equally important. And there is no superior or inferior relationship between fundamental right and DPSP. Both are complementing to each other. But now a different trend is coming. Now a different argument is coming that we also need to read fundamental right and DPSP along with fundamental duty. We need to add fundamental duty also along with fundamental right. But so as I said, it's new ideas or new concepts are coming into fundamental right, and this is evolving and growing as our democracy is maturing. Our fundamental right composition and content is also growing, or new things are coming into it. So, but what we need from common man perspective is that first we need to have a constitutional awareness. Our common citizen, like our presenter has said, that under Article 17 there is a provision for abolition of untouchability. But how many of us know that the provision is written in Constitution? The rough idea is that it is legally known, but we don't know that it is already there in Constitution. It is violation of constitutional provision. If you talk to common man, even a general educated person, they don't have idea that it is a violation of constitutional principle if you practice untouchability. Similarly, under Article 27, no person shall compel you to pay tax for implement of a particular religion. Chanda, we used to collect chanda for any kind of religious program or cultural program. So it is violation of fundamental right if we look into fundamental right. So what we need, the starting point must be, as for the topic for common man, we need to create awareness about constitution. We need to create Mahabharata, Gita, or any other religious scripture. Constitution need to be, known by all democratic. In a democratic country, all citizens need to be know about Constitution. I think the process has been started. Firstly, in case of at least in case of school or higher education, this year the government of India has started celebrating Constitution Day, where there are special provisions for reading fundamental duties and fundamental rights. So I think this year this program has been started. At institutional level, at government level, the process has been already started. The next step must be come from our level, from academics and all the intelligence section or educated group who can contribute to this government effort. So what I want to conclude is that the process of getting awareness regarding Constitution has been already started. As a member of civil society, we can complement to government effort. What government has started this time. Okay, that much, Vikas. Thank you. Vikas.
Subrat.
Yeah.
Subrat Kumar, please give your thoughts.
I think Subrat is there. Subrat.
Hello.
Yes, you are.
Subrat, we are audible.
Thank you, Ankit sir and Jaran bhai. Kids are already discussed all the perspectives of fundamental rights. I don't need to analyze all these things, but I have some questions to Ankit sir to discuss about right to health and right to leisure. You know all that our constitution does not say about our right to health, because no case has been filed in the court to discuss about right to health, or it has any connection to right to life. So, but in recent condition of our NEET problem, NEET exam, court decided to maintain silence about NEET exam, but does not say about right to health. Don't you think right to health is related to our right to life? Is there any difference of right to life and right to health? My first question is there any difference between right to life and right to health? Because in the interpretation, I don't think any difference between right to life and right to health. But just analyze our recent condition of NEET exam. What do you think about right to life and right to health? First question. Second question, what about right to rest and leisure? So don't you think it is necessary part of Indian society? Don't you think it is a necessary part of Indian society to stop our labor exploitation, or to stop or to take measure of different to take measures to create different acts or policy to protect our labor. So please, two questions: right to life and right to health, and requirement of right to leisure in the discussion of right to life. Ankit sir.
Okay, Subrat, we got your point. I think we'll start our question answer session. So if most of participants, they think they could write their questions, so please write your questions in the chat box. And if any other one wants to discuss, like Dhiren also is there. So Dhiren, do you like to speak something about this fundamental right? Yes, Dhiren.
You're asking about to
No, no,
me,
I'm asking you, Dhiren, because you are more to this, subject, not that physics Dhiren. He's physics Dhiren. So you, so you are Professor Dhiren from Lady Siram College. So please have some of your point of view if you think that you want to add something, or you want to make some clarity or anything you like to speak.
Not really much to add. Ankit has already elaborated. So from different perspective, in different ways, we as social science students having many commonality, also certain differences, and he has a different kind of advantage from the perspective of the legal studies. So and all that he spoke, and he contextualized in the spectrum, on the entire history, the way things evolve. So, and what we take, as default from of rights. So, today that is given to all of us. It's immersed in different contexts, and it is important. So we have to, take all this, context important. So what I, just wanted to add. So we're talking about fundamental right. So rights that is foundational to our life. So as a person, as an individual, as a citizen, and when you are talking about this right, we are talking about so largely within the rubric of citizenship. So we need to place this history of right or the fundamental right. No, all of us. That is my just reflection. So to the history of right as such, you know. So you see the history of right uh, evolve. So since this the Aristotelian age, so the Platonic age. So if we can place the history of right as such, because the otherworldly things always talk about history of duties. If you look at the history of our civilization, we talk about the righteousness of order, dharma. So dharma need to maintain, and essential to that dharma is your duty, not right. And right, so never given. Rights are fought actually. Nobody has given us. We are all fought. So historically, or we are now fighting, and maybe for us and also for the future. And all of us needs to take these things into account. That is my things. Not to add much. So that constitution, that guarantee of all of us, and time to time different movement. In fact, that's how the rational choice, people, agency, group, time to time they have challenged and added also certain form of rights time to time that we need to take into account. Others, Ankit has already addressed from different perspectives.
Okay,
Yes.
okay, Dhiren, thank you. I think Bailochan, you wanted to speak something? Bailochan, if you want to ask some questions or
Yes.
you want to speak something.
Yes, because why I have 2 to 3 questions, basic questions that comes in my mind. So thank you, Ankit, for a nice presentations. Your presentation enlightened us in different ways. I have a 3 basic question to you, as you are the masters of these laws and fundamental rights, duties. So first question is: do you not think that in our country there is a huge gap exists between the theoretical perspective of human rights and fundamental rights and fundamental duties and the practices? That this gap will definitely, if even we do have some sort of theoretical knowledge, but whenever certain kinds of actions are being taken against us, we got terrified. So, what is your perspective on this? Second, can you suggest some of the good books which really encourage us to in different sense, so that at least the things that you have elaborated, the basic things that Article 22, different parts of fundamental right. So similarly, if we have some sort of understanding on certain laws by reading these basic books, then definitely it will solve many problems that we do face in our day-to-day life. And the third, but is very, very important to me, but recently I have faced in my life, while I return to my own village, to my place of work. At that time, I was driving the car, and the car speed was almost 65, but the highest limit was, limit is on the NH is 60. But an e-challan was, issued against me, and the charges was given because I violated the speed limit. And second point is, I do not have, this driving license. But although I do have, and I carried the, I was carrying this DL with me while I was driving the car, but the fine was issued. So, like me, many people, they do suffer in our day-to-day life, by the, certain forces or the state force, I can say. It is really a very, very pathetic conditions. So in such situations, what a common man should do, so that this kind of, arbitrarily find or some kind of putting trouble to some people will be minimized. I need your perspective on this. Thank you.
Okay, thank you, Balochan. Ankit ji, I think you have got many questions. Our enlightened persons like Subrat, Balochan, Dhiren have added to your points. So just to add to them, I have
Yes.
points.
Because just one minute.
Yes, please, bhai.
I just want to add one more question with Balachan's question, because before going to answer by the Ankit, so it will be better to explain the same type of a question, similar kind of a question. So I just want to add.
Yes, bhai,
Actually,
please go ahead.
how a common person to know the rule regulation, something change, something modification by the government time to time, how it will come to the common person to know just like the speed limit is this much, thus, and this is the rule to maintain the number plate kind of thing. This is the rules. How the common people will know? What are the way? What are the platform? How the common people to know this type of changes?
Okay, bhai. Thank you, Sushil bhai, for your question. Just to add what Subrat said in the beginning.
Am I audible?
Yes, Sushil bhai.
Am I
you are-
audible?
Yes,
Hello.
yes, you are audible, Sushil bhai. Sushil bhai, you want to ask more questions? Okay, Saurabh. I just wanted to add what our esteemed participants talked about. See, I think like Subrat asked you that what about right to health and what about labor protection. So I think we most of the time we confuse with legal rights and fundamental rights. See, for the labor protection, if I say there are many labor laws which protects the rights of the labor. Even though it also works about the welfare of the labor. So you also know the Supreme Court has categorically said when the Article 31C comes, Article 14 goes. So it means when directive principle of state policy has to be worked out. So only at that point you can just avoid fundamental rights. Otherwise, any law making or when you prepare your law, you must keep in your mind the fundamental rights. So how to means the for the layman it is very difficult. Everybody thinks that to everything we should bring it into the ambit of fundamental rights, but it is not possible because what will happen that fundamental rights will lose its in the uniqueness if you bring everything under fundamental rights. And secondly, what happens that even if there are fundamental rights, I think you mentioned about Keswanand Bharati case. So during that time, what happened that the constitutional amendment is required to change the fundamental rights if you bring everything into this ambit. So this kind of problem will come, and there will be much more litigations Supreme Court will face, and all these things happen. But I would like to also ask the recent judgment of the Supreme Court regarding this reservation system, like in the SC/ST, to bring it to the economic angle or economic aspects. So, how do you think that when the constitution makers they framed the constitution, they focused about the social and educational backwardness, to give, you can say, the affirmative action to uplift, the poor or the vulnerables or the, social backward people. So at what point you think that we have changed our perspective to see the constitution also? So do you think that we are weakening, what constitution makers thought when they prepared this, the holy book, I would say. So this is the first question, and the second question, as in the beginning I mentioned, so how we have to distinguish between fundamental right and legal right. So, and if legal right could serve our purpose, do you think we should curtail much more fundamental rights to make it more unique, to not to violate, and it should be limited to right to life, or that kind of thing which is not actually can be taken during the emergency time also. I think with this I will hand over the stage to you to answer one by one, Ankit. So we would like to listen to you.
Okay, thank you, Dr. Vikas Kumar Malik, and thank you. I just want to say one thing, that if I forget a question, kindly remind me of the same, because I have heard many questions in a row, and let me try to answer them. So, first of all, there is a question initially. I'll start from what I can say, the less complicated and less adversarial ones, means very not that much, which cannot be much interpreted into, it is very simple in nature. So first, there was a question about that right to health and right to leisure. So yes, right to health and right to leisure, both they should come under Article 21 of the Right to Life, and they are recognized by the courts of law, Honorable Supreme Court of India, very much earlier. And in very famous case, you have talked about labor laws. So the we can say the fountain of labor protection in India, it comes from the Bandhuwa Mukti Morcha case. There was a case during the Asiad village, for construction of Asiad village, 9th Asiad, we have studied in school. And during construction of that Asiad village, the laborers were constructing that village or accommodations. Their work, their work condition was very much deplorable, very much bad. And there was a case by a social rights organization for their right to health and their right to life and for better labor conditions, and that there only Supreme Court has recognized the importance of right to health. It was the first case, and another case there was called Rakesh Chandra Narayan. I think there was a case versus State of Bihar. In that case also, the Supreme Court has time and again it has emphasized on this right to health. And this right to health is no doubt a fundamental right. And as I have also said, also in that Rakesh Narayan case, the Supreme Court also said that it must be the duty, although there must be crunch of funds and there must be other practical constraints, but it must be the duty of the state to provide basic health care or necessary health care for all the citizens. And I think it is also there in the DPSP, Directive State Policy, but also it is also recognized by the court as a fundamental right also. And another thing in this case, latest development in this case, I think Ramdev Baba, regarding Ramdev Baba, he was doing some gathering in Ramlila Maidan, and there was a case, Ramlila Maidan versus Home Secretary Delhi or something. In that case also, there was Justice Swatantra Kumar, famous judge in India, and along with another Justice Chauhan. What they did, they recognized also this right to sleep and right to leisure. It's also a fundamental right, because they recognize this right to sleep and leisure as a necessity to continue the human existence properly. Without sleep, without leisure, a human being cannot function properly. Ordinarily, they cannot function properly, and they will be soon, their capacity will be diminished. diminished. So yes, by laws of the land, by the Honorable Supreme Court and Honorable High Courts of this country, and the right to sleep, right to health, all these are recognized. But another questions comes from most of the participants, that the distance between the application and the law text of the law. This is a very complicated question, I must say, because it is up to our administrative machineries to implement. The parliamentarians, those legislators, and those judicial bodies, they can only recognize and they can only create the text of the law. But the implementation at the grassroots level, it requires first strong implementation, and secondly consciousness of the people, consciousness of the stakeholders in general, all those who are involved in these things. So this is the first question. And later there was a question by this Dr. Dhendra Sahu, my dear friend. He was asked that where do you go if our human rights are violated? It is also a good question. If our human rights are violated, human rights are ensured to us by not only by the state laws of our country, but also by the United Nations. We all know, and for that only, as India is a signatory to that conferences, those United Nations conferences, India has also created this specific forums in national and state levels, like National Human Rights Commission or State Human Rights Commission, who specifically deals with this human right violations of private people. However, those are not the only forums which you may approach. You may approach to any legal forum directly, any kind of courts, and even police, as per your legal need. So, what kind of human right is violated? Whether it comes under the constitution only, or it is specifically violative of certain other statutes or other laws of the state, or it is due to some administrative action, or it is due to some private action, it is due to some community action. Because I have personally seen in certain cases in human rights forums, human rights commissions, cases comes where both the parties were public and general. One group of people violating the human rights of another people. So there are many complicated kinds of human rights abrogations are there, and so ultimately, usually it is the judiciary and specific forums like Human Rights Commission. They are always there, and they have become gradually. I am not saying they are quite transparent and they are not that means helpful, but gradually they are getting more and more accessible to general public, more and more transparent, more and more economic also, and so gradually the access to justice of ordinary public is increasing. So this is the about human rights. So then there are questions from Mr. Boylochan Behra, another good friend of mine. Boylochan Behra, कमेंट कर दोगे काइंडली कौन कौन से प्रचार चले
अंकित भाई सुनंदु तीनटा क्वेश्चन थिला फर्स्ट क्वेश्चन हैला कि देयर इज ए गैप बिटवीन द थ्योरी एंड प्रैक्टिस ऑफ फंडामेंटल राइट्स ओके इन इंडिया जोतरी कि अनेक लोक पढी चंती फंडामेंटल राइट्स विषय रे बट व्हेन इट कम्स इन द इंप्लीमेंटेशन पार्ट ओके many people they are afraid of because of lack of some sort of awareness which is already been discussed in the platform. So I need your perspective that what do you think, how can we bridge the gap between the theory and practices in the context of our education system, okay? And the second thing is the basic books that really give some sort of concrete idea about the implementation part. and third is about the kind of harassment that is done by the state force, I can say, to the common people by implementing arbitrarily laws or rules that is there in the for the protection of for example the incidents I have explained. These are the
Last question.
questions.
Third question that can repeat kariyo third question
Order. Last question. थर्ड क्वेश्चन बेसिक जेतेबेले सपोज जोटा सुशील भाई भी पचारले कि आमे जेतेबेले आसचु गोटे एनएच हाईवे रे डिफरेंट पार्ट्स रे डिफरेंट स्पीड लिमिट लिखाई छी राइट सपोज आपण गोटे लिमिट वायलेट माने जो लिमिट दिया है रूल दिया है यू वायलेट दैट रूल सो यू शुड बी फाइंड फॉर दैट राइट बट जो जिनसटा पई आपण already documents achi and then again they are putting fine on that without checking the documents valid documents then what a common man should do because it is also they are putting common man to a very trouble situations okay financial burden and moving from one office to another office like this then what should a common man do in such situations so that this thing cannot be repeated in a same manner or in a series manner okay so what is your perspective on that yeah
So first of all, I'm starting from the first question that about the distance between theory and practice. So right. It is kind of means very widely faced dilemma or widely faced issue. It is not only this; it is done seen here in regarding the fundamental rights, but in all the cases where our government is involved, the law enforcement agency is involved and all that. So as a ordinary human being, without ordinary human being means upstanding citizen who is knowing he is well educated, but he does not have possess any specific extra powers like he is not a political leader, he does not have political power or financial power, he is an ordinary person. So from that point of view, what we can do, it is our best interest to be not be should not be adversarial in nature. Adversarial in nature means when if something bad, some rights is getting abrogated, we should not give reasons to any other party or any other person, so which can be used legally against us. We should be first. We should understand what is the issue and whether in practice we have a legal standing or not. So I have seen it is not that much. Hard because I have seen people they try even if they are not from legal background but humanities background even they start trying to understand the law, the text of law, knowing the law whenever they get into this legal situations. So right. I have seen it is not we should be first be calm and we should try to know where our legal standing is and what our rights and duties are and then only we should act on something to devise a plan or something because theory and practical have always been different in our especially in our country because there has been corruption issues, there has been education issues because many people are not educated, they don't know anything. Even if a police officer goes to them and says, no, you cannot stand on the road, you have to pay the fine. The road is for moving vehicles, they will pay the fine. So, very fundamental issues with us are there. So, as an ordinary person, only we can know, first we have to know the rights and duties. Then only we can search for a particular forum or that, so that this distance between the theory and practice will be minimized. Gradually, it is happening. Gradually, it is happening, and people are getting conscious. But ultimately, in a country like ours, like 140 crores people, ultimately the consciousness will work. Everything we cannot, just like Mr. Malik has said, everything we cannot put upon laws and put upon courts. We cannot give depend on those institutions for everything. So yeah, and another thing I can say that now that there is a Gandhian principle of autonomous areas, autonomous villages. So here also, if we can say, we can have autonomous civil societies in small areas, and we'll be conscious, we'll be in touch with our local police, local revenue officials, local law enforcement officials, then it would be very helpful for the common. So it is another my own opinion. So it is one thing. Second question is that yours
related basic books.
Basic books for the law of the land. The government of India freely provides the textual content of the laws. Textual laws are, we call them in legal language, bare acts. Means it is pure acts. It does not, and basic explanations it also has, but no theoretical textual behind explanations. Only basic necessary explanations. Search online, and today at our fingertips we have smartphones, so we need not purchase any books to learn the laws. Still, if you want to, as a learner, or you can have a good book about Indian Constitution, and there are many good intelligible books for ordinary person, from those people who are appearing for UPSC and who are like public ad, they must know better than me. So there are good books, and in my personal opinion, not only Constitution should be read by everyone, but also it should be taught in all the graduating level courses in India, at least one paper. At least there is STEM, there is science,
it should be.
everything, medical, everything, because it speaks about how our country is made. So everybody should know how our country is made, basic things. So this is my second answer, and hardly about this practical aspect of said that how their means they're exploiting some elements of government. They are exploiting these laws and giving false notices. Even if a person does not have does have license, they are sending e-challans and all. So this is this e-challan concept in this particular case. This is because the technological aspect of law. So here, it is no one is obstructing a person while going. No one is asking for a driving license. No one is asking for helmet. No one is asking for speed limit. They are directly getting your number and sending a notice online through the home. Right. So those people who are doing this are allegedly misusing the technological aspect of law. Yes. So, in my opinion, let us why not use that technological aspect of law towards our own advantage. How we can say, first to say, there is in these cases of traffic violations, it is regarded as petty cases, small cases, and usually it does not go to the trial level, usually. Okay. If a person, if you are not if you are not giving that e-challan, you are not fulfilling that e-challan, and suppose some your driving license is confiscated or made not working. It is not working by government action. You can simply go to the file a complaint in a court of law or any that, or you can ask RTI that why your driving license is suspended or everything, and then you go to the court of law, and there are many small level judicial bodies who handle this kind of cases, and First of all, what I have known from experience that usually what they do if they don't get summons to appear at a lok adalat. That you have not giving fine someone to the court to face your charges that you have violated all this and all. So don't get threatened. Traffic violations are very small. You can go directly to the whenever you are threatened to go brought to the court of law. Always understand the court of law is regarded as an expert of experts. And usually learned people are there. Usually learned people are there. You need not fear them. If you confidently put your what I would say your side in front of them that sir, look at this issue, I am not doing anything, they have given me false, and if you have any supporting evidence with that, usually they will leave you unharmed. So only what these corrupt people do, they utilize your fear of courts and police. If you stop being afraid of courts and police, they cannot do anything. So stop doing anything and always know the law. And also another thing is that even in our smartphones, if we hear our GPS, we have GPS in our smartphones, that can be also used to track us where we were there, and even in some cases it can use to know our speed also.
Right.
And so we can use technology for us also. We can use that technology to our own use and prove that we are not over speed limit and this was a false case. So at that time, if someone is threatening you, you can say that to them, look, I have GPS in my phone. It proves that I was under speed limit.
Right.
Okay. So need not be afraid. I have seen many cases where that try to make you afraid. Some people get afraid and pay the fine. Some people don't get afraid and drag them to court. So let us stop getting afraid of law. Usually court is our friend and they will protect our right. Sometimes what happens, yes, definitely, we have seen in many movies and all that there are issues, people get very too much pain from courts. In Odia, we will say, Sarvostanta Higala. So this is only in extreme cases this happens, and there are special kinds of cases where it happens, not in these cases. So don't get worried.
No, I am not getting worried, Ankit. I also met the NDI and he said it's that well because
I was saying about any common man who is listening, don't get worried, you are an educated person.
Because of misuse of this technology, government suffer a lot. My question is that so somebody misuse the rule, then definitely, for example, if somebody is a daily wage laborer and he drives bike, and he was for that, then definitely certain days he has to leave his work. So that financial burden plus other complications achi. So fine is not the major things, but the point that janaku but a problem because they have some sort of power, right? It is not some kind of violations from their side. More question
yes. Yes, right. Right saying you are perfect, but it is more of a question of corruption rather than
right.
More of it is of corruption and abuse of power, and power can only be at large scale. It can only be tackled by this education and consciousness only. In large scale, in general, we cannot have, because if a person does not know about his rights and remedies, then how can we empower him to tackle this kind of this corruption? So this is in large scale. In ordinary scale, this is the there is no sort.
Right. Thank you so much.
Ankit,
you.
can I ask you? What you said actually, very much appreciated. But one point I would like to add. See, to am I audible, Ankit?
Yes, yes, sir.
So I would like to add, as you very nicely answered Goilochan's apprehensions. Also, Susil Bhai also add to that. So let me also tell our participant here that the very fundamental thing we know, ignorance of law is not excused. So in any time, so like Boylochan said that he was at 65 kilometer per hour speed, but the speed limit was 60 per hour. So you nicely answered that you could also give him proof through GPS or any kind of thing that you have. But I would like to just add, see, first of all, we should not. What happens in my personal experience, I could say, when we go or when we are caught by police or any official, first we are hot. So we should not be hot in the first instant. We should at least understand and see what the case and what they are trying to say about us. So whenever also let me also confess, 1 2 times when I have neglectedly violated the traffic in Delhi. So police constable of traffic they have caught me. But what I have done, I have just get down from my car and I have talked to them. See, this was a negligence. So they after this behavior they drastically reduce the fine. So say it was a 5,000 rupees fine. They take a nominal charge and they give you warning. So it is not every time the case is not that they are there to exploit or they are there to hurt or they are there to for corruption only. So we should not generalize this thing. Rather getting generalized, we should be our like in the recent I think this act which is known as motor vehicle act. So it has been amended and the provisions have been very strict. So the fines have been very strict. So there are many violators are also. So we can say how to control them. So I think there are two aspects. You have very clearly mentioned that we should not fear, we should cooperate. And if like Delhi wage labor kind of Baluchan said, if we are there, we should also raise voice for them. So if we stop saying for them, then also this thing escalates. So I think as a civil society or educated person, our role also gets increased in this kind of thing, because I personally feel when educated people raise their voice, society automatically doesn't require much more laws to be abided by. Thank you.
Exactly, because I completely agree with you. Actually, in my cases, that was not a technical issue or a technically violence or something else. In my cases, I had been caught by some officers, and they have charged me fine for my number plate that was written in italic word. Right. I just asked what is the reason for a fine. They said your number plate is in not proper manner. There was a guideline to what will be the size and what will be the numbers number size and shape. Then I just simply I did not recognize. I did not give my identity. I just simply asked. It is my negligence. Sorry, it is my ignorance. Even I do not know where it has been published, and I just explain all these things. They simply reduce my fine and just give me a challan of 500 instead of rupees 2,000. I agreed, but they have also agreed. But how common people know this type of order has been passed, this type of rule has been changed. When I made my number plate, I just went a shop. He has shown me different type and size of letter, and asked me, you just select it. You just select one. Which one is you're looking very just as per your choice. I just italic size, and accordingly I have made my number plates. But it is my ignorance. Just is just due to this shop, he or she should know, he should know, sir, this is the rule, and this type of a number plate is not permissible.
Yes, bhai. Yes, in that case, bhai, you should tell that shopkeeper he must actually aware about this thing, and he should be fined for this thing. Actually, he should
Exactly.
get fined.
Otherwise, I will go for this italic word. I must select what is the permissible one.
And why I think Ankit will answer you, but I think awareness will play a crucial role. And what happens, like after I elaborated my case, I write to DCP Delhi that you have
Yes.
not properly aware our people on the roads where to take diversion, where not to take diversion, and you have done very temporary things which is even not visible. So the DCP also answered me, yes, that they are making, things to happen properly. So, but what happens? That it is also a case that we also do not give proper advertisements through different manner. So, in many cases, and where it about common man, it's about awareness. So, until unless we aware our people, like see, brother, you are a very educated person. I am also, but we don't know about how the nameplate has to carry at what manner, because we are dependent on our shopkeeper. So then we got fined. So then common man is also far away from us. So we have to also think. I think we have.
Yes, yes.
Yes. So
Right.
Ankit, please add to it.
Then one more thing also, I also met the officer in charge of that team squad. Then he just shown me a paper cutting where the advertise where the public notice was issued. So that's why I completely silenced, and I just whatever the fine charge I just gave him and written away.
Right, that's the best. That's the best way to cooperate with our.
Exactly. That I have done. Then I did not tell tell about myself, and I just simply asked where it was published, or they show me a paper cutting where public notice was issued. So I completely agreed with them and gave my fine.
Yes.
Okay, thank you, Ankit. Please check.
That is also, brother, just Ankit, I'll take just 30 seconds. So that is also our problem in Indian society, that for a small problem, we open up our identity, we say we are this and that, and our brother is this and that, our relatives are this and that. So that creates more nuisance. So I think we also through this, program, we should aware ourselves. So for the small things, we should at least cooperate our authorities, because they are there to make the law and order smooth for us. So Ankit, it's to you now.
Yes, you have clarified it quite well. I don't have, I don't know, I don't want to add much either. However, I want to say that yes, what you have said, that we should not be get into adversarial mode, and you should behave like a law-abiding citizen. We should get, and also as the person who made this query, Swai sir, he asked how to know the law. All the laws that they are ever changing, and how to ordinary person will know how to write his name plate, or how to write his number plate, or how to ride a bike with or without helmet, whether the person who's sitting behind at you from you, whether he needs a helmet or not. So there is no shortcut to it. We have to be conscious about changing laws. We have to that paper cutting. We have to know about that new legal news daily, and sometimes there are news from local authorities when they change some laws. Sometimes there are news regarding the judgments of Supreme Court where laws are changed. So as a person belonging to civil society, it would be little easier. However, for those who are not that much educated or conscious, or they don't have time to know, it is very hard for them. Of course, I understand. there is no shortcut to it. As a citizen, model citizen, we should try to know as much as possible, try to cooperate with government authorities, and as Malik sir has already said, that ignorance of law is no excuse. We cannot say that we don't know the law. We have to, it is imperative. It is required from us to know the law. So we should try as much as possible in cooperate with authorities. And if our is violated, our fundamental rights is violated, someone is forcing us to pay undue fines and all that, definitely we should seek redressal from proper forums, definitely. So this is my little bit of what answer that is. And yes, Mr. Boylachand had also added that arbitrary charges is the problem. Yes, arbitrary charges is the problem, and there are legal forums to address that. But before going to the legal forum, should first help us to prove our case in a court of law, because when a case is instituted and law enforcement authorities, they are delegated by the government to enforce the law, and so they are the duty bound people. We are the ordinary citizens. So if you want to redress some issues against them, we have to be legally strong. Our footing should be legally strong. And definitely, this concept is very hard to do for those people, marginalized people. Anything in larger, if you say take it as a larger context, only the conscious growth of consciousness in education can hear it in the larger context, cure it in a larger context. And yes, there are ways to circumvent these arbitrary charges, but we have to know about them, and we have to make our case legally strong. Our part legally strong, and the first part, as the organizer said before, it starts with not being reactive but being cooperative at that place of occurrence. And so,
thank you. I have one addition to the discussion and one question. The addition is that I think recently there is a change in the laws that the number plates is now available with the showrooms, right? You have to go to the different shops and to design it, but now it's available as per the laws. So I think that part is covered with the new changes adopted by various governments. Okay. So, and my question is, as per the constitution, we have fundamental rights, and that guarantees that we have right to expression, right? We have the fundamental right to expression. But there are certain legal laws, like IT laws 2000 or IT laws, IT Act 2008, which restricts us to express certain things in digital platforms. So where these contradictions are there? Because one hand you are giving me freedom, and other hand you are restricting my freedom. So where it is fundamental rights? Where is my freedom of expression?
My answer is that there was a case in 2015, I think famous case, made by a law student, a litigation made by a law student named Shreya Singhal. In that case, that section 66A of IT Act is held to be violative of the Constitution, that freedom of speech and expression. And also, so it is not, we cannot say that Honorable Supreme Court of India is not completely unaware of the plight of the people and regarding the freedom of their speech and expression. It recognizes that sometimes governments are trying to suppress the voice of the people by various administrative decisions and all. But another part which we have to understand while expressing our freedom of speech and expression is that in that same article in the Constitution of India, there are certain reasonable restrictions are provided. The terms like public order and terms like relationship with foreign friendly states and like national security and national integrity. These terms are used. These terms are why it is used in the exceptions that these things has also need to be protected while protecting the individual freedoms of speech and expression. These things are also required to be protected. Here, there must be a fine balance between an individual right to freedom of expression and some public interest or national interest, because in practical nature, if we continuously abuse some foreign leader and in with that as the outcome from that abuse, that foreign country's relationship with our Indian government is harmed, then we might as a whole, the nation as a whole, face some financial issues or some social issues or any kinds of issues. So there must be a fine balance between this freedom and restrictions as to this for national interest to public interest. But who will decide how the balance should be there? Who will decide? So this is a that a question means delicate question. So here all we can say that we have to return back to the fundamentals, to our state. That we all know that there are pillars of the state: executive, legislative, judiciary, and there is fourth pillar, media. All these pillars, if we go back to them, it is indirectly their duty. It is their duty to make a balance between individual freedom and community interest. So ultimately, it is their duty. So we have to abide by the bureaucratic decisions and the Supreme Court's protections of our rights and the legislators' consciousness, because time and again, when we delve into this question, we usually keep the legislators' interest to the backseat. So when we adopted a democratic constitution, we have not only democracy is not the only thing. There is secularism and there is republic and there is other things. But democracy is also the basic features of the constitution. So when we have basic features of democracy as a basic feature of the constitution, democracy speaks about representation of peoples being able to formulate laws. So when our own representatives who are directly elected by us are making some laws, if they are somehow we are feeling that somehow they're suppressing the freedom of expression, then what we can say, we can say indirectly it is the opinion of the people to suppress those kind of expressions, because ultimately we have adopted this democratic concept, and the voice of the people is with our legislators, and to check and balance them there are judiciary. So if at a particular time, if certain we think that our voice is suppressed by government or public authorities, we should get a democratic solution to this. We should try to or we should try a constitutional solution for this. So either we should go to the court for redressal for enforcement of the freedom of expression, or we should select those kind of our representatives, those our MPs or MLAs who are interested in freedom of expression, or we promote such kind of media, which is the fourth pillar, that which will propagate this freedom of solution. It is our duty, especially duty of the concerned citizen and the civil society, to express our opinion in a constitutional way. And we should not. I am not in favor of violent demonstrations and all. These are not the solution. Rather, solution should be constitutional one, to approach proper forums, to express our political rights, to express our right to vote in a proper manner, so that the solution will be sustainable. Right. So this is my answer.
Thank you. I think with your answer, I got two more questions here. With your
Okay. Okay.
Yes, I want to have it. So I think recently we have Puttaswamy judgment, right, which enables us with the right to privacy. Right, but recent days you see a lot of technology has been installed in various platforms, which have automatic scanning system like face recognition and other things, right? So how do you see that the one hand we have right to privacy and other hand this face recognition technology? And then my second question is the recent past we have witnessed a lot of judgments which is favorable towards a political narrative. So there are a lot of experts who are saying that it's a politicization of the whole structure of judiciary. So if that is the thing, how do you see this the idea of balance and check of having independent pillars in the democratic form of society?
Yes, so both of questions you are very much good questions. I was expecting something like this since the day I found out the topic. So first of all, first of question is technology. There is face recognition technology and the right to privacy. It is a very we have started facing this problem now, but it is there in Western societies since that 9/11 issue. After 9/11 issue, that there is a act called Patriot Act came into existence in the United States, where the security agencies they were allowed to tap into any kinds of phones, read every emails, access any cameras, and totally, completely, that privacy is gone. But the state of fear in their society at that time was so high that people did not mind giving up their privacy. So the answer here also it lies that how much we are, concerns about our security. Because if a privacy is allowed, then privacy is allowed to all parts of the society, including the antisocial parts of the society also. And if there is a scrutiny, there is a violation of privacy or scrutiny by the government, the face recognition, also it is also applicable to the good people of the society also. Not only it is taking away the rights of the bad people or the antisocial elements, but also the good people. So it is another, it is our point of view that how much scrutiny we want in our private lives and how much security we want. And sometimes in this age, they are not they are very hard to become the same. Sometimes less the security you have, more the independence you have. So whether we should totally become a police state or the scrutinized state, or totally become a state respecting the privacy of the individual. So another thing is that
it's like the chicken and egg story. Who come first?
Yes. It is very hard to strike a balance, because when we give freedom to people, it is bound to be misused by some, and when we restrict some people, it is bound to harm certain good society, definitely. So again, this is a case of current need of the society. There is a maxim in common law. We say the welfare of the people is the supreme law. Salus populi suprema lex, we say. Means welfare of the people is supreme law. So if a state follows this principle, then welfare of the people is more important than privacy of the people. And protection of life, this is, we can say this is a US model or Western model of privacy. But sometimes countries they prefer to keep their people alive than to make their lives private. So this is there is no definite answer, and as per you, you can reject it emotionally or ideologically, or you can accept it ideologically. And another question you have in second part you have said about, kindly remind.
Second question is that recent past we have witnessed that fewer judgments from the Honorable Supreme Court. It somehow some expert says that it's a politically motivated, or do you have kind of favor towards political some kind of political group. So in that particular scenario, if you look at the traditional belief of democracy that all the institutions need to be work independently, we are
Yes.
getting balance. So in
Yes,
that
good.
scenario, this is happening. So how do you see the future of this judiciary or legal scholarship in India?
Before, yes, got your question. Before seeing this, going towards this, whatever you say about the politicization of this certain kind of machineries, we can we might remember another case. There was a case means there was a happening in before some years ago. There was a particular person who is a presiding judge of Kolkata High Court, and he was temporarily for some time he was arrested for giving certain remarks and passing certain orders which are derogatory to the decorum of law and which are prohibited by the Supreme Court. First time people knew that just like executive and legislative and media, this third pillar of the state, our state, the judiciary, it also had human beings. Earlier, but this culture of deification and that from British era, they came into people's mind, and this that there must be gods or deities or something. But first time they realized that they are just like human beings. They are just like ministers. They are just like prime ministers. They are just like senior IS officers or foreign service officers. So this this issue of politicization you are saying, it is a very one kind of say if true. I'm not confirming that is true. It might be controversial. So if true, it may be taken as a positive sign that people are starting to realize that it is another pillar of the state, and just like other three pillars of the state, it can also have issues, it can also have adversities, it can also sometimes act against the interests of the people. And also, it is not my words, but when the
Judgments are not against the interests of the people. Those are the interests of the people.
sometimes they are never, and sometimes
Legalizing legalizing the gay and lesbian. It is a favor of social people. It is not against the people. But the time
definitely. So that there is happening that poor senior justices from the Supreme Court may hold a meeting conference and also certain remarks about the functioning of the court. So all these things, the politicization, all these things, whatever you are saying, this is can be taken as a positive way so that people will be conscious about this part of the state. And numerous times, as I have said, people talak and the rights of the transgender, and there are people judgments in issue, many judgments protecting human rights. So definitely, that just like any other pillars of the state, just like there are many leaders we have seen in legislators, statesmen we have seen in 17 and 70 years, done many there are many institutions also in this pillar of the state. We have to realize just like we are processing evaluating the other three pillars of the state, we have to also evaluate these pillars of the state. First thing. Another thing which usually people not from the background of law don't know, that there is a function that is called a judicial functions of a court, and there are things called administrative functions of the court. When the court acting judicially while adjudicating a matter or making judgment of a matter or giving judgment of a matter, it should not be questioned. It is beyond questioning. It is conclusive in nature, final in nature. It should not be questioned. However, when a court is acting in its administrative capacity, it is just like any other organ of the state, and it also liable to be scrutinized and discussed about, and even if information can be sought about this. There is a case, it is not very famous, but case of Odisha, which is covered by Karan Thapar in Hindustan Times, in Sunday Times, where there was a person who due to the administrative actions of particular court, but he overstays his jail term by 10 years. There, for this faulty administrative system, I'm not saying about the judgment. Judgment is quite good and it's beyond reproach. It cannot be criticized because it is supreme in nature. I'm saying about the administrative part. So in administrative part, here the administration of the that particular body, they had to pay fine to that person. It is the case, one of its kind case in whole of India, and the victim name was Pratap Naik, and the advocate name was Prabir Das. He is a fellow alumni of Utkal University. Many of people must be knowing him. And it was a landmark case in this case, but no other case after that came to that footing. So the administrative function will have to differentiate from other functions. It is just like any other, machinery of the state, and we should be also treated as a part of the state. And if, just like if a collector or any other official is get politically influenced, we take certain thoughts about it. We get conscious about it. Similarly, in this case also, the civil society should get conscious about it, should deliberate about it, should not be afraid of it. This is my answer.
Thank you. Any other questions from our audience?
No, another question I totally skipped. There is Mr. Jaram Singh Samal. Let me answer that. He was asking that role of Supreme Court, freedom of expression. Yes, so freedom of expression, I have already answered this question. I think for you, I think freedom of expression, numerously it has been strengthened by the Supreme Court judgments, and starting from the famous case of Maneka Gandhi, and there are many cases, and that Otto Shankar case, when the freedom of expression of a convict who is sentenced to death, he is also allowed to publish his statement and put his words to the book. Even there is a book with the expressions of, with the opinions of the assailant or the person who is convicted of the murder of Gandhiji. That was also published. So freedom of expression is quite, I think, protected in our country, and protected by judiciary. No person, even not the criminals, are even deprived of it. Yes, however, some instances come where that sometimes a particular government or particular bureaucratic machinery, they try to suppress some voice, but it is not sustainable. In India, it is not sustainable. In this technological age, it is. I don't think it is very easy to suppress, to restrict the freedom of expression of a person, unless we become, authoritarian regime like, our neighboring countries. It is very hard. So it is quite protected. Okay.
Thank you. Any other questions before we go for the final remarks? Any question from the students? I think we have registered all of the questions. Bishop bhai, is there any question in the YouTube live stream?
Yeah, there are few questions, but nothing related to this topic. Actually, it's mostly logistic related, but otherwise, it's no questions.
Okay, okay, thank you. I think with this we have almost done with the sessions. Before we close the session, I just want to request Dr. Sahu to make a final comment that how we should educate people or aware people about the legal scholarship, right? And the role of law in larger individual life. Because if you look at Odisha, I think most of the people will go to study law not by choice, right? Because that is the scenario. Because if you don't have any other things to do, okay, let's go do the law, like some other colleges which is like near to your place, right? So how do you change that particular narrative? I just want your final comments on this. Then we'll go to the
Yes, so in Odisha, yes, it is quite true, and I think this question once I was asked in an interview for a teaching post by Barampur University some years ago. The same questions that what about the situation and how to change it. So first of all, changing before changing an issue, first of all we have to accept the issue that it exists. So primarily the issue exists. People usually they don't prefer legal studies. They sometimes they are forced to study law as there is no other option available. Sometimes they are forced to study law just that because it's kind of a part-time hobby, and very few people are actually coming to study law to actually study law or make a career out of it. But gradually, what happened? Gradually, the opportunities, social and employment-related opportunities grown, and now it is a very good. It is a good. Subject to pursue because the employment opportunities have grown, and practically in our society, employment is the primary motive these days, and so yes, gradually growing. But I would like to first think that eradicate. First, we have to eradicate the social stigmas regarding it. That it is the law means look and right, and law means you just have to appear for the exams, or you need not appear for the exams. You will automatically get passed out. Or there are stigmas like a law degree will not cannot sustain you as per employment is concerned. So to eradicate this, look, everywhere is not the same. We cannot generalize. There are good institutions in Odisha who are providing quality legal education. First of all, secondly, law as a subject has grown and providing multidimensional opportunities for all the skill sets of people, not only those who have skills, high skills, analytical skills, but also who have other, other kind of aptitude, and there are banking jobs, there are insurance jobs, there are independent advocacy professionals, there are taxation related legal professionals. Many avenues have opened, and currently, if you say, it would be very hard for you to stay unemployed after a law degree. It would be very hard to stay unemployed. Employment is quite available, and so another thing is that even if an institution nearby you or accessible to you is not providing quality legal education, you can try to be self. Also, UGC is starting this self-study programs, that online programs. So this is an era of self-Atmanirbhar Bharat. So even if your institution accessible to you is not providing education, quality education, you can yourself have quality education on yourself, and take online classes. There are free online classes these days available, and you can appear for self check that self-guiding curriculums, and you can compete. So it is not. I can encourage all the people who want to have a career in law that get into it. Just like any other professional course, humanities course, it has very good opportunities. And now also to promote the higher education and legal studies, the post-graduation in law is reduced to 1 year in tenure in certain institutions. Not all the institutions, but some institutions, the tenure is reduced to 1 year just to promote the post-graduation degree, so that more people will do it and come into academics and research purposes. So yes, this is my view regarding legal scholarship and legal studies. If any prospective person wants to do or wants to guide someone else to do. Okay.
Thank you so much, Dr. Sao, making this particular talk very comprehensive and lucid to everyone. I think your legal expertise is quite vast, and the way you carry out lecture from the beginning to the end, it was outstanding in nature. I think apart from that, I'd like to thank both the discussant, Mr. Behera and Dr. Samal, along with others like Dhiren Bhai and others. And also like to thank you, our chair, Vikas Kumar Malik Bhai, and thank you, Vishnu Bhai, for the YouTube live streaming. And also like to thank you, Deepak Bhai, for his encouragement and his ideas to run this particular show. And with this, I'd like to thank everyone and special thank to Dr. Ankit Saurabh. Thank you. With this, we'll call for the day. Thank you.